Good morning. Are you Paul McCorvy?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does.
Mr. McCorvy, in cause number 24 DCCR 1914, you're charged with the state jail felony offense of theft of property from July 3rd of 2024. And how do you plead to that charge?
Guilty, I guess, non-guilty, no contest, whatever. Guilty.
Either you did it or you didn't do it. Are you guilty or are you not guilty?
I guess guilty.
There's no I guess. Here's the thing. If you're not guilty, we can set your case for trial. A jury can decide if you're guilty or not. If you're guilty and you want to take this agreement, then you have to plead guilty, but you also have to take responsibility. It's not just going through the motions and saying, I'm pleading guilty, but I didn't really do it. So, to the charge of the state jail felony offense of theft of property, how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yeah.
And are you pleading guilty because you actually did what they charged you with?
Yeah, I guess so. Yeah.
You're about to get your case set for trial.
No, ma'am, I did it. Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes,
And it looks like the agreement that you've reached is for a 4-year deferred probation. There would not be a fine. There would be restitution ordered in the amount of $2,500, and you would be required to follow all of the other rules and conditions of probation. Is that your understanding?
yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. McCorvey is not competent?
No, Judge.
And Mr. Nichols, since we have that restitution and
Judge,
it's
I
a
would ask
state
that we
jail
go forward today.
with sentencing.
Yes, Your Honor.
So what I'm going to do, Mr. McCorvey, is waive the pre-sentence report, and we'll get a post-sentence report. And order, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation. Was it 4 years? Sorry, my computer's locked.
Yes, Your Honor.
For a period of 4 years. You're ordered to pay $2,500 in restitution and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, then the case will actually be dismissed at the end. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? It's very important to me and obviously to the victims that that $2,500 gets paid. So I want you to start making payments on it immediately.
As soon as I possibly can. Yes, ma'am.
And another thing that can happen is if you get that paid off and you do everything you're supposed to on your probation, get your community service done, fees, fines paid, do everything right, it's very likely that you could get off probation early.
I have community service on this also?
Yes, everyone on probation, it's required by law that you have community service. And so they'll let you know what that amount is. But the sooner you get everything taken care of, if you do it all correctly from the beginning, you can get off. I sign early terminations all the time. But you have to do it all correctly, otherwise you'll do the whole time, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Maribel Reichel. Good morning. Are you Zarek Trustee? Mr. Trustee, in cause number 25 DCCR 0981, you're charged with.
All right, pause right here. This is one of those moments where the stakes jump fast. We're about to hear 2 separate felony charges laid out back to back, and the punishment ranges are no joke. Pay close attention because what the judge explains. Next is exactly why plea decisions in cases like this can completely change someone's future. Ask yourself, if you were facing decades behind bars.
The second-degree felony offense of aggravated assault with a deadly weapon and that's from June 19th of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 25 DCCR 0982, you're charged with a first-degree felony offense of aggravated robbery from June 19th of 2025. What that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? I have here on the tablet in each of those cases plea bargain rejections that you've signed with Mr. Parker that shows that the district attorney's office has made offers in each of your cases. Hold on a second. For 15-year terms in prison that would run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that? And do you want to reject those offers and have your cases set for trial? And Mr. Coleman, is there any reason that the state, is it any evidence you're waiting on or any reason to believe that those offers would change?
We don't anticipate any additional evidence, and there is no inclination or any information that we anticipate that would affect the offer that we made in this case.
So, Mr. Trustee, I want to make sure you understand, after today, when your case goes on the trial docket, I will not accept these plea agreements after that. You could change your mind, plead to a different number, or plea open to the court, but it's not going to be to the same offers. Do you understand?
And Your Honor, just for the record, last time we reset because there was a video that somebody provided me, and we had them come up here, and they provided that to the DA's office, or ultimately to the police station. And just so he knows that Mr. Coleman is aware of that video, but it's not changed his offer.
Okay.
Well, I say video as a message.
Okay.
This is a critical turning point. The judge just confirmed there is video evidence, and even more importantly, that it did not change the prosecution's offer. That tells you a lot about how the state views this case. Once a case hits the trial docket, those plea deals usually disappear for good. Drop a comment. Do you think rejecting a 15-year concurrent deal here is bold or reckless?
Okay, perfect. So, Mr. Trustee, I'll get your case set for trial. Mr. Parker has been appointed to represent you at this time. He's one of the attorneys who represents a lot of defendants here as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, speak up, please.
Yes, ma'am.
All right, so Mr. Parker, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay?
I have videos. Can I turn those to the court, or?
Yeah, if you will, hand those to the clerk. If you'll make a notation, whoever we appoint, make sure they know we have them and they can come get them from our office. You can go back with the bailiff. Thank you,
Thank you,
Mr.
Judge.
Parker.
Oh, Your Honor, he's was wanting me to ask the court about the bond reduction. I think it's bond to.
I'm not
We
gonna,
ask for time.
yeah, well, nothing's been filed for a bond reduction. You can talk to your new